focus in UMA is to have civic education, which we're doing here, and civic engagement, which we should be doing as Muslims, right? And in times of dire need that we should have been doing way, way before. So we have today our dynamic speaker here with us from ACLU, which I'm going to have Ms. Abdus Ahmed, who's the chairperson of organizing this event, and one of our board members as well, to introduce Michael Chase from ACLU. At the end of his talk, you are free to ask questions. You have index cards we'll pass out. You can write the questions down, and we'll ask the questions to Mr. Chase, and we'll go from there. So without further ado, Ms. Ahmed will come up here and introduce Michael Chase.
Hi, Assalamualaikum. My name is Chandni Ahmed, and I'm a board member of UMA USA. I know all of us have many questions about government surveillance, and we have been participating in discussions and conspiracy theories about our rights and what government surveillance is. So we are fortunate today that we have Michael Chase from ACLU joining us and educating us about our own rights. Let me give you a brief description of ACLU. ACLU stands for American Civil Liberties Union, and it was found about more than 100 years ago, right, Mike? And they were found to preserve and defend our rights and liberties, people's rights and liberties, according to the Constitution of United States. So they're fighting for our rights, and they have been involved in many campaigns. Mike has been mostly involved in issues related to government surveillance, police misconduct, immigrants' rights, racial justice, and free speech. So let's welcome Mike on stage so he can come and talk to us.
Thank you so much, and it's really my honor to be here today, so thank you very much for having me out. I've done some public speaking, but I'm not a super pro, so I'll do my best here. But the ACLU mostly is about what government can and cannot do, because that's what the Constitution's about, the limits of what government can and cannot do. We've been in the U.S. Supreme Court more than any other organization in U.S. history. One thing we do a lot of is to strike down laws that are unconstitutional, and that has been our biggest thing so far. But we're broadening out. We're becoming more of a grassroots organization and lobbying on state laws, affecting policies, including local policies like police policies regarding surveillance, and a variety of other things. Our membership has quadrupled since Trump was elected president, from 400,000 to 1.6 million, and we're very busy with a lot of things. We're aware, of course, that the Muslim community is being targeted, particularly now, right after Trump became president and instituted the Muslim ban, which his people have the nerve to call a country-based ban, but obviously it is a religious-based ban. We challenged that, and we've won consistently in federal court, defeating Trump over and over again. So that's kind of what we're all about. I'm a member of the board of the Northern California affiliate, but also of the board for Alameda County. So that's here, Oakland, Fremont, etc. I've been in Fremont since '82 myself, and have seen all the great changes that have happened to make Fremont a more diverse and strong community. I have a immigrants' rights kind of set program. I'm going to try to pick out the parts that I think are most relevant for you folks. A lot of times when I've given the talk, it has been to Latino communities, so there's been a lot of discussion about ICE. If people want to hear about that, I can do that, but I'll probably forego that and talk more about rights at borders, including airports, and rights with police encounters in general. But before I do that, Andalib had mentioned an interest in surveillance. So I wanted to speak about surveillance in general. It's something that's an issue that matters greatly to me in the broader context, and of course, the surveillance of communities like Muslim communities is of great concern to the ACLU. Surveillance comes under the Fourth Amendment. By the way, I'm not a lawyer. The only thing I know about is constitutional law. But I do know about the Fourth Amendment and the Constitution. And it prohibits unreasonable search and seizure. So searching is part of surveilling. I can say just in general that the law has not kept up with technology. So for example, there's an old case, a 1975 case from Maryland that basically said it should be okay to surveil people's telephones or gather data, so-called metadata, because after all, people gave the phone company permission to know every number they called and every number who called them. That's bogus in today's era, because today we have computers that can do so-called data mining. And we have demonstrated how, by knowing the people who called you, who you called, who you emailed, who emailed you, location data, we all have a tracker in our pockets, most of us, a cell phone. You can put together a picture of a person's life. All the individual tiles may not mean much, but when you put them all together, you have a kind of mosaic, which tells you a great deal about a person. And so that data mining is something that the law has not kept up with. Here in California, I had the honor of actually lobbying the governor who signed the bill, even though everybody said he wouldn't, the California Electronic Communications Protection Act, which basically says that you need a warrant in California to search someone's phone, for example, or their electronic devices. So we have some protections in California, but the national law is from 1986. Imagine that, before the internet, right? So we need to catch the law up with new technologies. Of course, just straight up surveillance, drones with cameras that can see in great detail what's happening far away, or even fly around close to you, unobtrusively. They don't even make noise. And all the other types of surveillance, So we're concerned about that. A particular concern of mine, and one that I promote internally within the ACLU, is to talk more about what is called in court the chilling effect. The idea is that if people know they are being surveilled, they will behave differently. And that's wrong. That should not be happening. I personally kind of refuse to cave into the chilling effect, and I'm out there saying all kinds of stuff that I know gets me on all kinds of databases, and that's okay. I'll fight the use of those databases to do anything to me, but I'm not going to be silenced. So the chilling effect is important, and we need to be aware of it. I think in the ACLU we need to bring it up in court more often. So with regard to surveillance, and talking about surveillance of Muslim communities, it's not so much that there is a law that we would declare unconstitutional. It is, as a matter of strategy, more calling out police departments at the local level, or the NSA, for example, at the national level, for doing things that they should not be doing. Okay, so we're trying to learn what they're doing, we're calling them out on it, we're suing them when we can, and trying to stop them from doing it. And there's a little bit of a game of whack-a-mole going on there. But we continue to fight, and we usually have won, and we're going to continue doing that, I think. So one, just to let you know how we go about doing that, the first thing is to find out what they are doing. So we have so-called FOIA, or sometimes called sunshine laws, Freedom of Information Act requests. That's how we find out what the government's doing, or we attempt to. When we find it out, then we bring it up to the public, and if someone's rights are being violated, we can sue. So for example, on the NSA generally, somebody was involved, actually I think it was an organization that we work with, EFF, said that the NSA surveillance was unconstitutional, and the court threw it out because they said that the aggrieved company, which was Verizon, the phone company, didn't have what's called standing. That is, they could not prove that they were being harmed. Well, that's a government game. They say, you can't prove you're being harmed, and the reason you can't prove it is because it's a secret. I mean, you can't find out. It's like being on a no-fly list, and you can't find out that you're on a no-fly list. And by the way, the no-fly list includes lots of people under the age of 6 months, so I guess they're dangerous terrorists. So errors are made. But we came back with another case. It's called NSA versus Wikipedia, or Wikimedia, excuse me. It's an ACLU case, and that is progressing, and we're doing well on that. It's to stop so-called upstream surveillance. But what we're looking for also from federal courts, and they agreed that we had standing, and so we're proceeding. They also said there was a reasonable chance we could prove that we could win the case, so that is moving forward. And the goal is to stop the NSA from intercepting the millions of telephone calls that they're currently intercepting. At one point it was foreign nationals, then it was foreign nationals who communicate with any American. And it's all part of what you might call, or we call, dragnet surveillance. One of the basic ideas in surveillance, or for that matter, Fourth Amendment searches, is the idea, it's right there in the Fourth Amendment. You have to be precise about who it is you're searching. You can't just do a fishing expedition, cast a big net, get information on innocent people in the hopes that you might catch somebody who you think you should be looking for. It has to be narrowly targeted. And the other one is there has to be some kind of probable cause. So there are different legal standards. Reasonable doubt is one, and then probable cause is higher. The language of the Fourth Amendment says there must be probable cause before you can do a search. So we're working on that case. We just last week filed a case dealing with airports, and I'll speak a little bit about airports, but we said that the CBT, the Customs and Border Patrol, should have at minimum probable cause before they search the electronic devices of anyone. The CBT, the Customs and Border Patrol, has asserted a lot of rights that we don't think they have, but they haven't been decided by the courts yet. So the suit we're bringing will begin to bring up those issues. What are the limits of their powers? But I can tell you in general that the CBT has a lot of power, and they're able to do things that ICE cannot do, for example. So that's being litigated, and the best outcome would be that they would no longer be searching the electronic devices just willy-nilly, as they are now, cell phones and laptops of people who come into the country. But let me talk about one particular case, which has to do more with, it's surveillance against a Muslim community. It's a local police force. It happens to be the largest city in the country, New York, the NYPD, and kind of how that played out. I'm not aware of a similar case locally. Well, I would be aware if there were one, where a local police department has been called out in a way that the NYPD and New York City Police Department was called out, and we haven't done that locally, but that doesn't mean that we wouldn't. So I'll give you a phone number later, but if you're aware of things that you would like the ACLU to know about, I'll give you a phone number, and you can call them. We'd love to hear from you, and you can tell us what's going on. Right? So, for example, if you feel that a mosque is being surveilled or other things are happening, let us know, and we'll see where we go. But I'm going to tell you a kind of story. It's actually going to be things that the ACLU said about it in New York. So this is from March 2017, several months ago. New rules guard against unconstitutional. Actually, let me back up. I'm sorry, I'll do another one first, a fact sheet about what was going on. Fact sheet on the NYPD Muslim surveillance program. This is from the ACLU. So these are facts. Since at least 2002, the New York City Police Department's Intelligence Division has engaged in the religious profiling and suspicionless surveillance of Muslims in New York City and beyond. The NYPD's Intelligence Division has singled out Muslim religious and community leaders, mosques, student associations, organizations, businesses, and individuals for pervasive surveillance that is discriminatory and not conducted against institutions or individuals belonging to any other religious faith or the public at large. The Intelligence Division units engaged in the NYPD's Muslim surveillance program include its demographic units, renamed the Zone Assessment Unit, the Intelligence Analysis Unit, the Cyber Intelligence Unit, and the Terrorist Interdiction Unit. Where has surveillance taken place? It has swept up Muslim communities throughout New York City, as well as every mosque within 100 miles of New York, extending to Pennsylvania, Connecticut, New Jersey, and more. Why is the NYPD spying on Muslim communities? The NYPD surveillance program is based on a false and unconstitutional premise that Muslim religious belief and practices are a basis for law enforcement scrutiny. The purported rationale for this unconstitutional surveillance is captured in a 2007 NYPD Intelligence Division report titled "Radicalization in the West, a Homegrown Threat." The report claims to identify a radicalization process by which individuals turn into terrorists, a, quote, process so broad that it seems to treat with suspicion anyone who identifies as Muslim, harbors Islamic beliefs, or engages in Islamic religious practices. For example, its purported radicalization, quote, indicators include First Amendment protected activities, including wearing traditional Islamic clothing and growing a beard, abstaining from alcohol, and becoming involved in social activism. How is the NYPD spying on Muslim communities? The Intelligence Division uses a variety of methods to spy and to monitor on Muslim communities without any suspicion of wrongdoing, and they include mapping of Muslim communities. The demographics unit, now the Zone Assessment Unit, has mapped neighborhoods predominantly occupied by 28 so-called ancestries of interest, i.e. national origin, associated with Muslim populations, as well as American Black Muslims. The NYPD expressly excluded from its surveillance and mapping activities non-Muslims, such as Coptic religious, Coptic Christian, Egyptians, or Iranian Jews. That is, people who were in those zones. Only Muslims were mapped. Photo and video surveillance. NYPD officers stationed in cars outside of mosques have taken pictures and videos of those leaving and entering places of worship, recorded the license plate numbers of worshipers attending services. Remotely controlled NYPD cameras have also been placed on light poles aimed at mosques, and if they had them, they would have used drones at that time, I'm sure. Police informants. The NYPD has recruited so-called mosque crawlers to act as inside observers in mosques. They report on sermons, provide names of attendees, and take pictures inside of the mosques. Employing a method called create and capture, the NYPD has instructed informants to, quote, create conversations about jihad or terrorism, and, quote, capture and report the responses to the police. Informants are often selected from a pool of arrestees, prisoners, or suspects who are pressured into becoming informants. Police rakers. Teams of NYPD plainclothes officers called rakers have been deployed to Muslim communities where they can blend in consistent with their ethnicity and or language. They aim to compile information on the community, listen in on conversations at Muslim restaurants and businesses, and identify Muslim, quote, hotspots. Tracking individuals, the NYPD tracks people who change their names, investigating those who could be Muslim converts or who were, quote, Americanizing their names. Intelligence databases. The Intelligence Division has generated daily reports on innocent Muslims' lives. The names of thousands of innocent New Yorkers have been placed in secret police files. Information is kept both in an intelligence database and on standalone computers used to generate intelligence reports. What are the consequences of NYPD spying on Muslim communities? Stigma. Through its religious profiling and surveillance, the NYPD has imposed an unwarranted badge of suspicion and stigma on law-abiding Muslim New Yorkers. Interference with religious practices. The NYPD's suspicionless surveillance has forced religious leaders to censor what they say to their congregants for fear anything they say could be taken out of context by police officers or informants. Some religious leaders feel they must regularly record their sermons to defend themselves against potential NYPD mischaracterizations. Disruptions resulting from unlawful NYPD surveillance have also diverted time and resources away from religious education and counseling. Muslims have reported feeling pressure to avoid appearing overly religious, for example, by changing their dress or the length of their beards. Community fear. The NYPD's discriminatory surveillance has produced an atmosphere of fear and mistrust within mosques and the Muslim community at large. Chilling free speech. This surveillance has chilled religious speech and political activism, from engaging in public debates and protests to friendly coffeehouse banter, damaging law enforcement relationships. This unlawful profiling of Muslims has damaged its relationship with American Muslims, that is, the relationship between the police and Muslims, breaching communities' trust in a police department that is tasked with protecting them. So what happened? Moving forward to March, the second of two federal judges has approved a settlement with the New York Police Department that protects New York Muslims and others from discriminatory and unjustified surveillance. So the outcome was new rules. It's on us and on everybody to see if they follow these rules, right? New policies. The new rules govern when and how investigations are conducted and provide for an independent civilian representative inside the NYPD who will act as a check against surveillance abuses. The settlement was reached in two federal lawsuits, Raza v. City of New York and Henshaw v. Special Services Division, approved by judges in both cases. So this is a kind of settlement, right? This is an example of sometimes they're called consent decrees. Often they're unlawful or unconstitutional policing. Under the Obama administration, Eric Holder brought 19 of those for unconstitutional policing. There's one in Oakland where there was egregious misconduct, and the Oakland police agreed to reform themselves, and they're under federal court oversight to do that, and they still haven't done it, and that's an ongoing story. But in particular, this is more about the history of the case, but these are the provisions. Prohibiting investigations in which race, religion, ethnicity, or national origin is a substantial or motivating factor. Requiring articulable and factual information regarding possible unlawful activity before the NYPD can launch a preliminary investigation into political or religious activity. Requiring the NYPD to account for the potential effect of investigative techniques on constitutionally protected activities such as religious worship and political meetings. Limiting the NYPD's use of undercover and confidential informants to techniques on constitutionally protected activities such as religious worship and political meetings. Limiting the NYPD's use of undercover and confidential informants to situations in which that information cannot reasonably be obtained in a timely and effective way by less intrusive means. Putting an end to open-ended investigations by imposing presumptive time limits and requiring reviews of ongoing investigations every 6 months, a kind of sunset clause on investigations. Installing a civilian representative within the NYPD with the power and obligation to ensure all these safeguards are followed and to serve as a check on investigations directed at political and religious activities. The civilian representative must record and report any violations to the police commissioner, who must investigate violations and report back to the civilian representative. If violations are systematic, the civilian representative must report them directly to the judge. Removing from the NYPD website the discredited and unscientific Radicalization in the West report, which justified discriminatory surveillance, and affirming that the report is not and will not be relied upon to open or prolong investigations. The civilian representative is empowered to report to the court at any time if there are violations of these guidelines, and so on, and in any case to report to the court on an annual basis. The mayor is prohibited from abolishing the civilian representative position without judicial approval, and abolition by the order of the court is only permitted if there have not been any systematic violations for a period of 3 years. The civilian representative is specifically authorized to review not just the opening or extension of investigations, but also how they are conducted. They are specifically authorized to review the propriety of the use or extension of use of undercover officers and confidential informants. The plaintiffs are, list the names and some more information about that. So we'll see what happens, right? This is typical of what happens when there is local surveillance, right? So the surveillance is at the city police department level or the county sheriff level, right? Beyond that, talking about surveillance in general, there is a bill which I hope you folks can support, SB 21, Senate Bill 21, which brings transparency to surveillance. It mandates that all through California, when there is surveillance technology being acquired by local police departments or county sheriffs, there has to be an open and transparent process. And one thing you folks can certainly do is at the local level, come to meetings,